Hello guys, welcome back to my channel. So today we'll be continuing with our 6-part family law series which we started some couple of videos ago, and we are going to be looking at the 5th part, and this 5th part is titled Alimony. So let's get right into it. The other name for alimony is called maintenance. So it's popularly known as maintenance. Alimony is not a term, and particularly in Nigeria and under our Matrimonial Causes Act, which provides for alimony, is actually referred to as maintenance, and specifically it's referred to as spousal maintenance, because there is maintenance when it has to do with children. That one is maintenance for children, but the concept of alimony specifically has to do with maintenance of the spouses. So it could be either the man maintaining the woman or the woman maintaining the man, and we'll get to that in the course of the video. So now, when spouses go through divorce or separation proceedings, one common question that is asked is, will the other spouse support me financially when this marriage ends, or if this separation comes into effect, depending on which is sought. So this goes to show that this issue of maintenance or alimony, as we'll be using them interchangeably in the course of this video, it is something that is real and is a burning issue when couples are going through difficulties in their marriage that has now led them to either divorce or separation. Therefore, the definition of alimony or maintenance is money that a court orders one spouse to pay to the other spouse in the event of a divorce or a separation. And like I said earlier, it is clearly different from child maintenance, because the child maintenance is what we're going to talk about in the 6th part of this family law series. So maintenance or alimony specifically has to do with the maintenance or the financial support that a court will specifically order one spouse to pay the other spouse. And typically, it is the spouse that has the financial capability that pays the other spouse. So this brings us to note one major thing about alimony or spousal maintenance is that it can be paid by anybody. So the first thing that you have to note here is that it is not always the man that has to pay for the woman's maintenance. If it is established that it's the woman that is the financial capable spouse, she will be ordered to pay the man the alimony if the man applies for it. There are notable instances of such happening. The American singer Mary J. Blige was ordered to pay alimony for her husband when they separated. So that went on for years until she got an order to stop it. And we'll get to that in the course of the video, because it could last a lifetime. It can also be varied, or it can be changed. Now, having established that a woman can pay alimony, another important thing to note, which is also a factor of alimony, is that alimony is usually ordered by a court of law. So like I said earlier, the law that provides for alimony is the Matrimonial Causes in Nigeria. And if you notice from our previous videos on this family law series, I have always mentioned that Matrimonial Causes Act regulates issues on matrimonial causes with respect to marriages, divorce, separation, and now alimony. So what the law provides in the Matrimonial Causes Act is that it must be ordered. Alimony has to be ordered by a court of law. And as with all court orders, it is not ordered unilaterally by the court. It's not ordered voluntarily by the court. There has to be an application or a request for the payment of the alimony from whichever of the spouses that is making the request. So alimony is not automatically paid. The third key point about alimony is that it is usually a monetary amount, a monetary sum that is ordered by the court, and the purpose of it is for the upkeep and maintenance of the spouse that has requested for it. However, it is important to note at this point that the court can also make orders with respect to non-monetary property, that is real estate properties and immovable properties. The court can also make specific orders with respect to them, but all those things have to be brought and pleaded in court. So like I said earlier, is a court of law that will have to determine it. So whatever you want the court to determine based on property or alimony, you have to include it in the papers when you are filing for your divorce or your separation in court. The last key point to note about an element of alimony is that the order of alimony would usually outlive the term of the divorce. So the order of alimony will be granted during the divorce proceedings or separation proceedings, but then it could continue for years after the divorce. And like I said earlier, it could also be varied at some point. So it is important to note that the issue of alimony usually lasts a long time, except if there's a variation that gives it a shortened period. Based on these details, you will note that alimony is not a punitive cost that is awarded against one spouse. And punitive here means that it's not a punishment. So even if one of the parties was badly behaved in the marriage, it doesn't mean that alimony will be granted because of the bad behavior of one of the spouses to the marriage. Purely, alimony just has to do with financial maintenance, because you just want to maintain and provide for the other spouse who is less capable or incapable of doing so for him or herself. Now, having established the key elements of alimony, and we have noted that it is not an automatic relief in the course of divorce or separation proceedings. So it means that there are factors that the court will consider before it can order alimony to be paid to one spouse by the other spouse. And these factors have been enshrined in the Matrimonial Causes Act, particularly in Section 70 of the Matrimonial Causes Act. The first factor that the court will consider before it can order or grant alimony is the income and earning capacity of each of the spouses. This is clear enough because the court will consider the income and the earnings of each parties. What do they earn? What monies do they receive? So based on this, the court will consider everything that relates to what the parties receive as earnings or as income. So based on this, the court will now be able to know, that this party is really less capable of taking care of him or herself, or is even incapable completely of taking care of him or herself. The second factor that the court will consider is the financial obligations, the financial needs, and the financial responsibilities of each party. First of all, the court has considered the earnings, whatever they earn, whatever they that comes in, the income of the parties. The court will also consider their expenses, what are their obligations, what are their needs, and what are their responsibilities financially. And these will include particularly living expenses like rent, consider their utilities, the expenses that they make on daily living. So the court will consider the food, shelter, and clothing needs, basic needs of the spouses. So that's the second factor that the court is going to consider. Now, the third factor that the court will consider is the length of the marriage. Typically, longer marriages would typically induce higher alimony rates. This is clear because if the parties have stayed so long in the marriage, it means that they have been used to a certain kind of lifestyle, and it means that they have endured so much and put in so much, invested so much in the marriage. So let's say if the couple has spent about 30 years together, 30 years of one's life, it's a long time. If the couple got married, let's say at the age of maybe early 20s, and then they stayed 30 years in their marriage, that means they'll be 50 something, and somebody that is already 50 something has already aged sufficiently. If it's somebody that is working in a civil service job, a job that will retire people at 60 or at 70, the person is close to retirement. So it means that this will also be a reason why the person will need a higher alimony payment from the spouse that is capable of paying it. So the length of the duration of the marriage is a factor that the court will consider. The fourth factor that the court will consider is the standard of living of the spouses. Now, this practically means that the lifestyle that the couple has been used to will be considered. So if the couple has been used to a certain lifestyle where they live in mansions and one of the spouses is less capable and cannot afford that kind of mansion, while the other spouse is capable of paying for it, then the court will put it into consideration if they are going their separate ways. The court will consider that the spouse that is less capable has already enjoyed that standard of living, so should still get something similar to that kind of standard of living. So this is what is meant by the standard of living of the couple, and that is what the court will consider too as a factor before it can grant alimony payment. The fifth factor that the court will consider with respect to granting an order for alimony payments is the age and the health of each spouse. The court will consider how old the spouses are. So just as with the length of the marriage, it applies to the age of the spouses. So typically, an aged couple that decide to go their separate ways in their old age, let's say at the age of 60, to attract more alimony payments because of their ages at that time. And at that time, it's more difficult for the spouse that doesn't really have anything to start doing something to earn a living at that time of the person's life. This is similar to the length of the marriage. So the age of the spouses is very important, and that's what the court to also consider. And so typically, if one of the spouses is really sick or has a condition that would deter the person or hinder the person from working, so the healthy spouse at that point will also be demanded to pay that alimony. So it's a major consideration that the court will look into. Another instance with respect to the health of the spouses is an instance where maybe one of the spouses had an accident in the course of the marriage. They may be young, but one of them had an accident that has impaired the person for life. The person is disabled for life. And then that spouse doesn't want to continue with him or her for some reason. I mean, you can't really force somebody that doesn't want to keep being married to a disabled person. But in that instance, the court will now consider that the disabled spouse is going to be really hindered from taking care of him or herself. And so based on that, it's a factor that the court will look into and to weigh on the mind of the court when granting the alimony payments for a higher stake for that disabled party. So these are the factors that the court will consider. However, it's also important to note that the factors that the court can consider are non-exhaustive. They are not restricted to these 5 factors that I have just discussed. So in the Matrimonial Causes Act gives the court discretionary powers, so they can think outside the box. So the court will just basically consider the circumstances of the party and factors that are necessary for determining the alimony payments. The next subheading we'll be talking about is how alimony is to be paid. Now, Section 73 of the Matrimonial Causes Act, which is the act that regulates alimony or maintenance, like I stated earlier. So Section 73 of the Matrimonial Causes Act states that the court can order that alimony should be paid as a lump sum or weekly or monthly or however the court deems fit. And this also shows that the law has given the court discretions with respect to making the orders that have to do with alimony payments. So when the law says as the court deems fit, so it means whatever the court decides. Following from all I've stated earlier, you will notice that the parties have some rights and obligations. So now one of the major obligations of the obligor, that is the party that is going to pay the alimony, while the receiving party is the obligee. So one of the major rights of the obligor who is going to pay the money is that he or she can apply to the court to vary it. If the obligor feels that the discretion that the court applied is too much, the obligor can apply to the court to change the terms. That's what we call variation. They can apply to the court to vary the order, to modify it a bit to how the obligor feels it's better or is more justiciable to the person. So the obligor can always apply to the court to vary it. Similar to the right of the obligor to apply to the court to vary, the obligor can also apply to the court in future at some point to also vary the order to the point of relaxing it completely. And this can happen based on circumstances, if circumstances has changed. So let's say the court put into consideration the age of the spouses or the length of the marriage, and now it is established that the other party, even though the person is aged, but the person now has some income or some investment that the person can use to take care of the person's self, then the obligor can apply to the court to vary that alimony that the obligor is supposed to be paying continuously. So the variation is in 2 ways: either to change the terms, to reduce the amount, or to structure, or to even completely end the payment of the alimony. Note that this could also work out if the obligor himself or herself also runs into a financial crisis and cannot pay the money based on that financial crisis he or she entered into. The obligor at that point can also still go to the court and make the same request for the variation based on the person's incapability now to continue to support or maintain the spouse. So it works either ways, either that the other party now has the financial muscle to take care of him or herself, or that the obligor himself or herself is no longer able by the person's financial standing to continue to take care of the spouse. So in whatever way, you can also approach the court to vary the order of the alimony payments. Another major obligation of the obligor is that he is obligated to make the payments. And if he or she fails to make the payments as ordered by the court, then it becomes contempt of court. Then as for the obligee's responsibility is to use the alimony payments for the purpose for which it has been provided. So the court cannot grant alimony payments to a spouse to be used for the person's maintenance as it is properly so called, and then you use the money on a spree. You use the money for things that are not specified, that the alimony is not intended for. So then you cannot come back again to make the request for those your basic needs, because the money that was given to you was for that thing and you didn't use it for them. So the obligee has that obligation to use the money for what it was provided for specifically, no more and no less. So now we'll talk about enforcing alimony orders. It is important to note at this point that enforcement is difficult, but it is possible. So enforcement is difficult because it has to do with enforcing someone to make payments, and it is possible because an alimony order, like I said earlier, is an order of court where the obligor has failed to obey the court order. First of all, the obligor has wrong contempt of court, and so contempt of court is a criminal offense which is punishable with imprisonment. So one remedy for an obligor that has failed to obey the court order to pay alimony payment is to charge the person for contempt through a contempt proceedings in court. Now, the second option is actually the option to make the payment. And just like with enforcement of monetary sums, you can garnish the obligor's account. In this instance, garnish has to do with the proceedings by which you enforce the judgment of court with respect to monetary sums. So in this instance, you can garnish the obligor's account, and this is done through a special garnish proceedings, which is done by attaching the obligor's bank accounts that have the monies in them. You attach it and go through the garnish proceedings in court. Based on the garnish proceedings, since you have attached the person's bank accounts, the banks will now be ordered to directly pay the obligee the amount that is supposed to be paid. Before I conclude, recall that I stated that alimony has to do with financial payments. However, Section 72 of the Matrimonial Causes Act has given the courts the discretion to settle properties. So like I said, even though alimony has to do with monetary payments and financial sums, the court can also delve into property. The courts have been empowered by the Matrimonial Causes Act in Section 72. So the courts can make orders with respect to properties that are owned by the couple, whether the couple have dealt with them in prenuptial agreements or postnuptial agreements. The courts can still make orders with respect to them. So generally, the courts have been given wide discretions with respect to organizing everything that has to do with the sharing of property or financial considerations and settlement for the spouses in the case of divorce or separation. So whether it has to do with monetary compensation, which is properly so-called alimony, or the settlement of property, the courts have wide discretions to determine what is justiciable, what is equitable with respect to the facts of each case. In conclusion, it is important to note that in reality, alimony is rarely granted in Nigeria. Rather, what is more focused on is the child maintenance. So spousal maintenance, that is alimony, is not really considered in Nigeria. However, it is possible and it can be granted in Nigeria as it is provided for by the Matrimonial Causes Act. So as long as one can establish the factors that will weigh on the mind of the court towards granting alimony payments in Nigeria, the courts will grant it. So alimony is possible in Nigeria and it can be paid by either party, whether the man or the woman. So if you're in a situation where you think you need alimony payments as you're going through divorce or separation proceedings, it is always best to consult your legal practitioner, so that the legal practitioner can assess your situation and guide you on how to approach the court with your request towards granting the order of alimony payment. So we have come to the end of this video and I hope you really got value from it. Kindly make your comment in the comment section below, ask questions if you have further questions to make. based on the topic, or any other issue that you would like us to talk about. And please do well to like the video and then subscribe to the channel so that you will get more updates. You will get notifications when we post more videos. Thank you for watching. I'll see you in my next video. Bye.